Welcome everyone to this special event. My name is Ken Coleman. I'm the director of the International Institute here at the university, and I'm delighted to kick off our celebration today of our 20th anniversary of the Institute. I will keep my introduction here brief. We want to get started with the main speaker who's obviously very special. It is absolutely fitting that our speaker today is Rebecca Scott. She epitomizes all that is wonderful about the International Institute, but also what is wonderful about this university. She's interdisciplinary, she's wide-ranging, her work has implications across space and time and discipline, and it is an honor for me to introduce her today to kick off this anniversary celebration. I think it goes without saying that she's one of our most distinguished faculty members here at the university. And I was thrilled when she agreed to do this lecture, and I asked her last fall. So Rebecca Scott is the Charles Gibson Distinguished University Professor of Law and History and Professor of Law. She teaches courses on civil rights and the boundaries of citizenship and historical perspective. Her recent book, published in 2012, Freedom Papers, An Atlantic Odyssey in the Age of Emancipation, has won numerous awards, and they're all listed on the program. It continues to win awards. It won awards in 2012, and it continues to win awards last year, and I'm sure there's some more to come. But this is the nature of her work. Her work is widely recognized, and it's widely cited, and she continues to produce books and articles that push the boundaries of our knowledge and also have very important practical impact. And on this last point, I want to say how humbling, but also how proud we all should be of the way that her work has pushed this debate about slavery on a global scale. Her work and the kind of energy around her statements and her definitions and her research on slavery are having practical implications in the realms of international law and domestic law around the world. And I have no doubt that they're saving lives and saving people from destitute and terrible fates. So this is a fitting introduction for me to be able to invite her to the podium on this wonderful occasion for our 20th anniversary of the International Institute. Professor Scott. Thank you.
Thank you very much, Ken. Thanks for that kind introduction. And Morris, you'll tell me if I'm getting feedback. Here we go. I'm very pleased to be here. When Ken issued the invitation to speak, he said, "We'd like to have you present some of your substantive work." And he emphasized that word, substantive. I think the implication was that this is not an occasion for exhortations and generalities and congratulatory reminiscences about international activities at the University of Michigan. So I took Ken at his word, and I'll try to suggest through substantive example one way in which detailed historical research and analysis may help to develop strategies with which to attack the forms of contemporary labor exploitation that are increasingly referred to as slavery or modern slavery. Now, as you might imagine, a historian's first response to the idea of applying the term slavery to the 21st century might be a raised eyebrow. Historians are the sworn enemies of anachronism. We always want to place terms in their proper chronological context. In the United States, we often think of slavery as the ownership of property in persons, as the original sin that marked our founding Constitution, as the evil that destroyed lives and would over the next half century after the Constitution tear the country apart. It would finally be abolished, as you know, with the 13th Amendment. Whatever abuses followed After 1865, it was no longer possible for one person to claim a right of property in another, to buy, sell, or mortgage human beings. It was no longer possible to impose physical punishment with complete impunity. Those of you who saw the recent film 12 Years a Slave undoubtedly have vivid images in mind of slavery's particular abuses and of the slave plantation as a place seemingly without law, without recourse to justice. Now, these images of slave markets, of field labor, of physical torment open up, I think, what seems like a kind of great gulf between then and now. Today, no one can purchase a person in Louisiana as Solomon Northup was purchased. One cannot legally purchase a person in Brazil, the last nation in the Americas to enact abolition, or even in Mauritania, one of the last nations in the world to abolish slavery. So here's the question, the philosophical, legal question. When there is no property in persons, can there, as a matter of legal definition, be slavery? Is there a meaningful sense in which what is called slavery today is in some sense continuous with slavery in the 19th century? And what I'd like to suggest is that historians, with their preoccupation with context, might actually be able to add a somewhat unexpected twist to that question of continuity. Slavery in the 19th century Americas certainly appeared to rest on the legal recognition of a property right in persons. That's one reason it was often called chattel slavery. But it turns out, upon examination, that although 19th century slaveholders sheltered behind the larger inviolability of property rights, they rarely had to explain where exactly the title to ownership over a specific named human being had actually originated. That is to say, in terms of property law, property theory, there was something a bit odd about the origins of the title to property in a person. Now, in the medieval Mediterranean world, individual enslavement had often been validated through the claim of capture in a just war, a rationale that, interestingly enough, opened up the possibility for someone to argue that in an individual instance, it had not, in fact, been a just war. In 15th century Valencia, masters were actually obliged to go before a judge to attest to the circumstances of the capture by which they claimed to hold an individual person as property. It may have been a mere formality, but it at least rested on the rationale of capture in just war. But by the 19th century in the Americas, very few people took the just war argument seriously. Everyone knew that the purchase of persons on the coast of West Africa had, my notes say, nothing much to do with moral rightness. I would now say nothing at all to do with the moral rightness of the conflicts, which were often mere slaving raids in which those persons might have been captured. Instead, within the mind of jurists in the United States, acts of initial enslavement were, from their vantage point, seen as having occurred offshore, out of sight, preferably in time out of mind. The subsequent incorporation of persons as items of commerce erased the question of origins, and a first sale conveniently established a chain of heritable property rights. But, of course, from an analytic point of view, the problem doesn't go away. If a person was to be held as property, how had a property right come to be created in that specific person in the first instance? The root of title to a given piece of land might rest on alleged first possession or a grant by the state based on its sovereign power. But to what could the claim to own a human being be traced back? By what legally recognizable logic had this individual lost what were generally regarded as natural rights in one's own person, such that those rights had become vested in another and exchangeable for money? Moreover, if you think about it, the purchase of a person implied that the individual in question was already the kind of person who could be owned, in effect that he or she was already property. So the right of ownership implied a prior attribution of status, that of slave, which was itself based on a right of ownership. So at certain moments, this uncomfortable circularity did force its way to the surface, becoming visible when the attempt to transform a person into property came into the open. So was slavery, in the historical period that we think of as defining true slavery, in broadly 18th and 19th century Americas for us, actually defined by legal ownership and property or not? You can see why this might matter for our use of terms in the present. If ownership itself if ownership itself is not the key to defining slavery, then something else might be. Now, when historians are faced with an analytical puzzle of this kind, our first reflex is usually to go to the archives. If we want to understand how persons came to be designated as slaves, we will try to catch a glimpse in the records of the mechanisms that were involved. And if we can get close enough to those mechanisms, we may be able to discern whether there are important points of similarity with contemporary circumstances. So as some of you know, from my point of view, the notarial archives of the city of New Orleans are the place to go. In each Louisiana purchase of a slave, sale of a slave, the parties were supposed to come before a public notary who then transcribed the entire text of the sale agreement into a permanent record. So we now have dozens and dozens of linear feet of such records. So if we look at these records, we can try to see whether we can discern the process of enslavement. Not the process of enslavement that occurred in West Africa, which has its own extraordinary dramatic history, which American jurists of the period, including Chief Justice John Marshall, tended to view as an area that was outside of Christendom and hence outside the realm of recognized law. That was Marshall's judgment in the case of the antelope. But instead, for our purposes, in order to get the close record, we want to find a case within the boundaries of the United States in the realm of federal and state law. So let me show you an example of a document that can open up a trail leading to a process of initial enslavement. This is a digital image of the pages of the notarial record. The document is dated the 23rd of September 1817. A Belgian-born carpenter and builder named Lambert Détry is selling a 19-year-old girl named Sanitte for 800 piastres to a merchant named Jacques-Emmanuel Baudry. So on the second page of the document, Sanitte is designated, probably not going to be able to find it because of the focus, but she's designated a négresse créole. She's designated as black. She's designated as Créole de Saint-Domingue, meaning born in the Caribbean colony, the French Caribbean colony of Saint-Domingue, the territory that's now Haiti. So it's not surprising that a 19-year-old born in Saint-Domingue might be in New Orleans in 1809. Many, in fact, more than 10,000 war refugees from Saint-Domingue had settled in Louisiana following their expulsion from Cuba, which had been their first place of refuge. Now, it's worth pointing out here that these were not, this is the standard image, these were not planters fleeing the slave insurrection of 1791. These were usually individuals and families who had stayed in Saint-Domingue after the initial phase of the Haitian Revolution, who had resided there during the administration of Toussaint Louverture, who ruled in the name of the French Republic over a colony in which slavery had been abolished. Sanitte was among those who fled during this flight virtually a decade after emancipation in 1803, in response to the Napoleonic military expedition that had been sent to crush the power of Toussaint Louverture and his fellow black generals, and in doing so had unleashed war and destruction. So these are war refugees of all classes and colors who fled first to Cuba and then were expelled from Cuba and on to Louisiana. So why choose this sale from the thousands that are documented in the notarial archives? One reason is because we can infer from the age that is attributed to Sanitte that she'd been born in Saint-Domingue around 1798. In other words, 4 years after the French National Convention in Paris, faced with the tumult of the Haitian Revolution, had taken the dramatic step of abolishing slavery throughout the French Empire, hoping to hold on to its richest Caribbean colony by conceding the single most important demand of the rebels. This is significant because for our purposes at the moment, it means that after 1794, no one in Saint-Domingue could legally be held as a slave. Children born to former slaves were born free. So we can make the inference from the date on the document, from the attributed age, and from her birthplace that she was born free. So how is it that a freeborn young woman was now being sold as a slave? How had a property right come into being? Now, the seller gave an account of how he'd acquired title to Sanitte. Détry recorded that he had bought Sanitte from Romaine O'Gorman, a free black woman, about 9 months earlier. Romaine O'Gorman had acquired Sanitte from a man named Robert Havard, 5 months before that. This sends us to another notarial volume, which shows that Havard had acquired her from Mathurin Simon. Mathurin Simon had acquired her from Madame Emily Daram in late 1815. Now, this harrowing sequence, 5 transfers of ownership of an adolescent girl in 3 years, mirrors the way in which ownership built upon itself, with one person after another passing along the apparent title to property. But when we reach all the way back to the sale to Emily Daram in March of 1814, we get a glimpse of that original claim of ownership on which this chain of title would be built. The initial seller in 1814 was a woman named Marthe Boyer. She had signed a power of attorney to a man named Louis Pomponneau. It's not much of a power of attorney as these things go, but it's a piece of paper, and she gives Louis Pomponneau authorization to represent her in a sale, and in this particular transaction. Now, Pomponneau was, like Marthe Boyer, like Sanitte, a war refugee from the city of Cap Français in Saint-Domingue. And on this occasion, his job was to explain how Marthe Boyer could offer Sanitte for sale as property. And to this end, he submitted a piece of paper. This is the piece of paper. It contains 2 unsworn statements dated in 1806, drawn up when all the persons involved were in their first place of exile in Santiago, Cuba. And the first one, in this sort of elegant, loopy handwriting there at the top, it's signed on the bottom by Baptiste Yo-Yo. I know about him, he's a food seller. Antoinette, Louise Moran, Magdalene Boisson. They affirmed that Sanitte belonged to a woman named La Fille Boyer, who in turn had given her to her sister, to La Fille's sister, Marthe Boyer. And they added that Sanitte had never had any master or mistress other than the Boyer sisters. This testimonial also has an odd 4th signature on the bottom left. As you can see, it appears to be glued onto the paper, suggesting that it had been cut out from some other document. The name in that case is Félix Doutre. He was a Saint-Domingue-born silver and goldsmith. He lived in Cuba before coming to New Orleans. We will come back to him in a moment. Now, this initial deposition seems to have been crafted to address the problem of how to anchor Marthe Boyer's claim to a property right in Sanitte. It uses careful language. It describes Sanitte as belonging to Marthe Boyer's sister, who then gave the girl to Marthe. Nobody in that first deposition uses the word slave. They don't make any reference to a purchase, a sale, or an inheritance. They simply state that Sanitte had had no other mistress than La Fille Boyer. This is a little bit like what lawyers would see as a claim of first possession, the claim that no one else had performed the gestures and actions that would have signaled occupancy and control. The second certificate on the same piece of paper, same day, one Monsieur Morin, he explains that he had lived near Marthe Boyer back in Port-au-Prince in 1802 or 1803, and he said he had always heard her said to be the slave of Marthe Boyer. And then he said that he always saw her serve Marthe in this capacity during the whole time that they were all in Port-au-Prince until the evacuation of the French troops. Now, if you recall the age, this would mean that the testimony here is that he knew Sanitte was a slave because she, at the age of either 5 or 6, was doing as she was told. Nowhere did any of these neighbors say what they all, of course, knew perfectly well, that the French National Convention had abolished slavery in 1794, and that slavery had never been legally reimposed on the colony of Saint-Domingue. Sanitte may well indeed have had no mistress other than Demoiselle Boyer, as the witnesses insisted, but this was, of course, because she was born free and had no legal owner initially at all. So what had happened to make possible what had been legally impossible in Saint-Domingue, the imputation of a property right in a person? Now, when during the summer of 1803, that first exile, people from Saint-Domingue had crossed the Windward Passage to seek refuge in Cuba, you can see here, you can see why people fleeing from Saint-Domingue, the closest place to go was the eastern coast of Cuba. When they made that crossing of a small arm of the Caribbean Sea, they shifted from one jurisdiction to another. They shifted from a jurisdiction without slavery to a jurisdiction that had slavery. And as they did so, some among the refugees sought to build claims to property and persons of the kind that they had been forced to relinquish in Saint-Domingue. But to do so required a kind of sleight of hand in which they would simply act, without ever saying so, as though these property rights in persons had not been interrupted by a decade of abolition. In that case, it seems to have meant inferring that the child of a free woman, the mother having perhaps once been a slave, could be construed to revert to the former status of her mother. Now, authorities in Cuba, which was at the time of expanding plantation society, also did not acknowledge the abolition of slavery for these purposes, for these legal purposes. They didn't acknowledge that it was something Napoleon had tried and failed to reimpose. They simply treated claims to hold property and persons as timeless, natural, worthy of recognition. But in practice, Spanish officials often could not quite discern by inspection who was meant to be subjected to such ownership. As scores of boats arrived in the port of Santiago and individuals and groups clambered ashore, it wasn't clear who was who. Who was to be designated a slave, who a domestic servant, who a free woman of color. The regional governor penned anxious letters back to Madrid saying, "What am I to do about those refugees of color who do not recognize slavery?" He was concerned that they might be concealing their true status. Now, this term recognition is kind of interesting. I think it's a clue to the nature of the property right that was now being asserted by one group of refugees over the others. We might think of it in this way, that revolution and warfare in Saint-Domingue had scrambled the legal and social relations on which slavery had rested. Within any given cluster of refugees, these social relations had in some way or another been reconfigured and now revolved around certain basic elements of dependency, reciprocity, intimidation, kinship, fear. And here I think we come close to the underlying meaning of the distinction that the nervous Spanish governor of Santiago was trying to make between those who recognized and those who did not recognize slavery. For in a slaveholding jurisdiction, the exercise of power over another person could be read as possession, and possession could then in turn be recognized as ownership. But the question was, who was exercising possession over whom? So how did Marthe de Boyer manage to cause such a recognition of slave status to be imposed on Sanitte while exempting herself from any comparable imputation, for she also was a woman of African descent? When Marthe de Boyer and Sanitte joined that stream of refugees, Sanitte was, as you know, very young. My hunch is that when they arrived in Santiago, the question of ownership probably did not arise. A 6-year-old would be hard put to claim rights as a free person, and no Cuban official encountering 18,000 war refugees was likely to worry very much about the status of a child who seemed to be in the care of one or another adult. But after 3 years in Santiago, it seems to be that after 3 years in Santiago, Marthe de Boyer concluded that she should take that step of convening her neighbors and putting on paper the perception that Sanitte belonged to her and had served her as a slave. Assembling these neighbors and bringing this document into being was a way, I think, of making very contingent social relations more concrete. It shifted Sanitte from the role perhaps of dependent to that of slave, and fixed Marthe de Boyer in the role of free woman and owner. Now, it was 3 years after these testimonials were drawn up that the thousands of refugees from Saint-Domingue who were living in Santiago were expelled from Cuba for complex geopolitical reasons. Most of them boarded boats for Louisiana. And here, historians, we try not to speculate too much, but I can kind of close my eyes and imagine the scene as Marthe de Boyer and Sanitte come down the gangplank or are rowed ashore in a tender. Marthe de Boyer's self-presentation as a person attended to by a young slave presumably reinforced her own status as a free woman of color. By acting as though Sanitte were unfree, Marthe presumably made herself appear more free. The officials supervising the disembarkation in New Orleans were quite willing, Louisiana officials, to accept such performances of ownership of some persons over others. And as the mayor and his employees did the count, they counted 3,226 of the refugees to be slaves, even though, of course, no person from Saint-Domingue had been a slave under law at the moment of their departure from the colony as refugees 6 years earlier. But while thousands of refugees had been loosely categorized as slaves, drawing up an actual bill of sale for any one of them might be difficult, for only rarely, if ever, did these putative owners have anything that might be taken as a recognizable proof of title. French law and revolutionary reality had extinguished the right of property in persons and ruptured any possibility of continuity in the chain of title. So preparing to sell a person as property thus required a kind of rerouting of the title, putting a new root on it. This became a moment for the production of paper that could in some ways trump the complicated shared history of wartime flight that united the refugees and instead divide them into, at law, into owners and inescapably ownable. Sanitte had reached the age of 10 in 1810, she reached the age of 12 in 1810, when the Legislative Council of New Orleans ruled, and this is despite the 1808 federal ban on the bringing into the United States of any person to be sold as a slave. That rule was suspended by the president, and the Legislative Council ruled that it was now possible for those who claimed such persons among the refugees to, quote, possess, sell, and make use of the slaves they had brought with them. And it was the following year that Marthe Boyer took the next step in the process of turning Sanitte into legally recognized property. She made an arrangement with a merchant named Antonio Serreyes, and they went to a notary to draw up papers certifying that Boyer was borrowing 150 piastres from Serreyes and securing the loan with a mortgage on La Négresse Sanitte. So at this point, in effect, we have a key step, because as the notary registered the document, he, as a Louisiana legal official, was recording Sanitte as a good that could be subject to mortgage, hence a good in which the person offering the mortgage had an alienable right of property. Now, as it turned out, the lender, Antonio Serreyes, was a little uncertain about the quality of Marthe Boyer's title, so he insisted that someone else should countersign it, that there should be a guarantor. And the man who stepped forward to countersign the 1810 loan document was Félix Doutre. Now, you might ask, how could Félix Doutre be sure that Marthe Boyer's title was good, so that he was willing to provide the guarantee? Well, it's hard to say, but somewhere along the line, someone had attached Doutre's own name to that old certificate of witnesses attesting that Sanitte belonged to Marthe Boyer. And at this point, I should say that we often use the metaphor of things being stitched together. We might say that the claims of ownership of property in a person were being stitched together. Well, if you turn over this piece of paper, if you just look at the back of it, I've turned it sideways here, you can actually see a small line of stitches where Félix Doutre's signature is added to this document, which is meant to create the title, which he is then going to guarantee. So Marthe Boyer had now succeeded in treating Sanitte as a saleable commodity for the purposes of obtaining credit. Now, in the end, she couldn't come up with the money fast enough. The judge, Louis Moreau-Lillet, authorized the issuance of an order of search and seizure of Sanitte in order to pay back the lender. Marthe Boyer scrambled, took another loan, offered Sanitte as the collateral to the second loan. For the lawyers in the audience, I know it doesn't make any sense, it's just what she did. She offered the same child as collateral for a second loan and paid back the first loan. So Sanitte at that point remained in Marthe's household. So we should note here, this here is how we're building up the argument pertaining to property theory. In effect, a subgroup among the Saint-Domingue refugees were developing a kind of unspoken rule of recognition among themselves. They would close ranks and they would recognize property and slaves based on a kind of loose inference from Ancien Régime titles, as if the Haitian Revolution and the accompanying abolition of slavery had never intervened. And this sleight of hand was accepted by one of the most distinguished jurists in Louisiana, Judge Moreau-Lillet, who had served himself as a legal officer in Saint-Domingue during the period of the abolition of slavery. So he knew perfectly well that slavery had been legally extinguished there. He's the one who issued the order of seizure and sale of Sanitte. The conspiracy of silence, or the conspiracy of legal silence, there wasn't silence around the revolution, there was legal silence around the revolution, had allies in very high places. Now, 3 years later, and you'll see how these two pieces of the story are going to come together, Marthe de Boyer decided to cash out, and she sent Louis Pomponneau off to the notary to carry out that sale of Sanitte to Emily Durham. Emily Durham accepted those ragged proofs of title. The price was low, 425 piastres, and by participating in the notarized sale, Durham was creating a plausible first link for herself for the chain of title. 17 months later, she resold Sanitte for 525 piastres to the bootmaker Mathurin Simon, clearing a profit of 100 piastres. On this would go through sale after sale, including the 1817 sale with which we began. Lambert d'Etry sold her to Emmanuel Baudry. Baudry sold her to Raymond Lafont. While she was in the custody of Raymond Lafont, she gave birth to a child named Cupidon. And when the baby was 1 month old, Lafont sold them both for 1,000 piastres to a free woman of color, Marie-Joseph Boussignac, who immediately resold them at a profit to a prosperous landholding family, I'm assuming with the intent that Sanitte might serve as a wet nurse. So by the 1820s, the right of property, the apparent right of property over Sanitte, had been so often documented that there was almost no imaginable way that it could be legally interrupted. Any trace of her free birth in Saint-Domingue was now buried under 9 notarized property transfers. So the claim to ownership of Sanitte had been created through a conjunction of paper and performance. The papers began as informal scraps of unsworn testimony, given added weight by being sewn into the notarial volumes of Pierre Pédesclot, one of the notaries. And once they were accepted as proof by the first purchaser and the notary certified the transaction, a chain of title commenced. Sanitte had been made into lawful property, that is, by being spoken about as property. Marthe de Boyer exercised the powers that were associated with possession and thus created an appearance of ownership. A neighbor had heard it said that Sanitte was a slave. Others believed that Sanitte had never had any other mistress. No one mentioned the name of Sanitte's mother or the circumstances of her birth. Everyone kept quiet about origins, and the notary's pen scratched away, and the child Sanitte became a person with a price. So now to return to our initial question, can there be slavery absent legal ownership of property in persons? The legal recognition of a property right in Sanitte followed from, it did not precede, Marthe de Boyer's exercise of the powers that attached to a right of ownership. In other words, the exercising of the powers occurred before any actual claim of ownership had been made. Marthe's capacity to exercise a control tantamount to possession arose from the circumstances of war and exodus and presumptions, and that possession was then read by the law as ownership. Marthe gave orders, Sanitte followed them. At first, no law at all backed this up. Then when Sanitte reached adolescence, and I think we might infer when she reached an age where she might have begun to challenge such control exerted informally, Marthe de Boyer went to the notary, where mortgage and later a sale transformed possession into legal ownership of the kind that would put state power behind the exercise of authority, that would guarantee that others could in sequence exercise over Sanitte the powers attaching to the right of ownership. Now that concept, that phrase, the exercise of the powers attaching to a right of ownership, provides one bridge to the present. That phrase was introduced into international law in 1926 by a committee convened by the League of Nations. Article 1 of the International Convention on Slavery, now ratified by more than 100 countries, reads, "Slavery is the status or condition of a person over whom any or all of the powers attaching to the right of ownership are exercised. Notice that it does not say that slavery is ownership. Instead, it names a set of powers, the powers attaching to the right of ownership. In effect, those that signal and then flow from control tantamount to possession. When those powers are exercised over a person, modern international law can now discern slavery. Now, it's my hope or hypothesis that the story of Sanitte should not really appear exotic. A child refugee was exploited by those in a position to do so. No one intervened to stop them. In the 19th century, the law looked at the relationship of Marthe de Boyer to Sanitte and deemed it ownership, the better to lock in those powers. Now, under modern laws against slavery, it should be possible to invert the process. We can look at certain relationships of control and discern slavery in order to bring the law to bear against those who exercise such powers. The details of the story of Sanitte, I think, are quite parallel to those that give rise to many contemporary forms of slavery. Refugees, including children, are often driven across borders. We see persons eager to capture the labor of young girls and lock it in. It is that lock-in, that extension of control to the point that it closely resembles possession, that in many instances constitutes the decisive marker of contemporary slavery. The mechanisms of control, of course, can vary from one place to another. They may include psychological intimidation. They often include the confiscation of documents. They often include repeated threats that any attempt at recourse to the authorities may bring prison or deportation. In other words, in the 19th century, masters could act with impunity against those deemed slaves because the authority of the state had conceded domestic sovereignty to masters. In the 21st century, masters can often act with near impunity against those they hold as slaves because the state is inaccessible to the victims, either because of fear and isolation or because laws have not been written or enforced in such a way as to provide recourse. Let me return to the phrase that I chose as a title for this talk, connecting thought and action across borders. In 2005 and in 2013, the European Court of Human Rights ruled twice against the French Republic for its failure to protect young women within its borders against the imposition of involuntary servitude. The French Criminal Code did not recognize any crime of enslavement or involuntary servitude, and many of the French judges did not think these terms appropriate, making prosecution nearly impossible. The first case to be appealed from the French court system to the European court had been that of Henriette Akofa. Some of you heard about her when I gave a lecture a couple of years ago in which I discussed this case in detail. She had been brought from Togo to Paris at the age of 15. She'd been forced into labor by a family who confiscated her documents, obliged her to work for 4 years, caring for children, cleaning the house, 10 hours a day, 7 days a week without pay, and with her passport confiscated. The second case concerned 2 child refugees from Burundi, one of whom was kept in isolation and obliged to work without pay. In addition to the gaps in the French criminal code, there was also, I think, a gap in the minds of prosecutors and judges. And this is one area in which I hope that scholarly research can help. There was a gap in their minds between conditions in modern Paris and the judges' own associations with the term slavery. The everyday reality of a young woman cooking and cleaning and taking orders within a household didn't fit with their image of cotton fields and whipping and bills of sale. But if we bring Henriette Akofa's predicament in Paris in 1994 into the same conceptual field as, in effect, Sanitte's situation when this document was being drawn up, we can see that alongside the differences, there is a fundamental parallel in the vulnerability, in the isolation, and in the impunity with which one human being exercised over them a set of powers that in 1814 could be called legal ownership, although in 1994 they could not. Now, in the summer of 2013, this is all very recent, it's stung by these 2 condemnations by the European Court of Human Rights. The French Parliament, I think somewhat grudgingly, approved revisions to the French Criminal Code. They simply lifted the language directly from the 1926 international treaties and moved it into the French criminal code, that the exercise over a person of any or all of the powers attaching to a right of ownership would now be declared to be the crime of enslavement. By moving this language into domestic law, they did open up a new front in the struggle against contemporary slavery, making it significantly more feasible, although we don't yet know how much it will in fact be done, but making it significantly more feasible for state prosecutors and independent activists to use local courts to try to halt these practices. Moreover, they made it clear, I think, clear may be too strong a word, they demonstrated, for those who wish to see it that way, that the use of the term slavery is not a mere rhetorical gesture. It's not simply an overstatement for the purpose of capturing attention. It's a concept that can be spelled out in law and interpreted carefully, as any similar legal concept needs to be interpreted carefully. Indeed, an international team of jurists and historians worked for 3 years to develop guidelines for interpreting that one sentence in the 1926 international law. And the Michigan side of the team arranged the translation of those guidelines into French and into Portuguese. So in these same months, the Brazilian parliament has been engaged in its own deliberations on the definition of slavery. Now, the context is very different. I'll be happy to take questions on the Brazilian situation because it is quite different from the French. In Brazil, the phenomenon of what is designated in Brazilian law labor analogous to slavery is quite widespread, particularly in the interior of the Amazon region, particularly in ranching, charcoal burning. The photograph on the poster is of a charcoal burner from Brazil, and sugarcane cutting. It affects thousands of workers over whom control is exercised through extreme isolation, psychological coercion, debt, and fraud. Now, interestingly, the campaign against contemporary slavery in Brazil builds on quite a strong set of provisions in domestic, criminal, and labor law. There have been hundreds of cases brought before the labor courts, a smaller number brought before the criminal courts, but the penalties are often small compared to the profits. There's a great deal of money to be made by lowering production costs, and only a modest amount to be lost by being forced to pay a fine as a result of a judgment of the labor courts. So the debate in Brazil has recently moved to the area of penalties, and a constitutional amendment has been introduced that would permit the legal expropriation of land on which owners have been convicted of using slave labor. You can see that this is a whole different scale of penalty from fines. As you might expect, the proposals triggered strong opposition from large landowners whose representatives have so far blocked passage of the amendment. It now seems likely, however, that the landowners will try to strike a deal in which they will accept the establishment of higher penalties in return for modifying the definition of slavery in ways that would make conviction very difficult. They wish to change the law so that only physical constraint on physical mobility will be considered to be probative of slavery. In other words, they would shift physical constraint from being a sufficient condition for proving slavery to a necessary condition. They would exclude all of the other indicia that have previously been used. Now, as a result of these debates in France, in Brazil, and elsewhere, I think that historical scholarship that explores the meaning of slavery has become fairly timely. It's being eagerly shared among researchers and practitioners, between those who dig in the archives and those who stand before judges and juries to try to convey why the term slavery can still have meaning in 2014. And this exchange, which connects thought and action across borders, has become intense and we hope productive. So in conclusion, I'm going to shift to a very brief example of something which I think Ken wanted me to refrain from doing, which is to give a couple of invocations of the extraordinary work being done at the University of Michigan. This will only take 1 minute. Each of you probably knows some of these examples. What's impressive is the conjunction of the parts. 2009, University of Michigan Law School established the first ever law school legal clinic dedicated to working on cases of human trafficking in the United States. From her office on the other side of South University, Bridget Carr and her team of attorneys and students take on the enormous task of pursuing the rights under civil law of victims of human trafficking. They've established a nationwide database of prosecutions while working one-on-one with victims, with prosecutors, and with investigators. Second point, University of Michigan's Center for Latin American and Caribbean Studies is assisting in the task of communicating research findings across languages by arranging extensive translation work and then making the results freely downloadable on the website of Latin American and Caribbean Studies. The most important contemporary essay written in Portuguese by Angela de Castro Gomes has been translated into English. Other articles on the subject have been translated the other way around from English into Portuguese. Third point, beginning of this academic year, the University of Michigan's Brazil Initiative, in conjunction with the law school's program in race, law, and history, brought to Ann Arbor 2 Brazilian jurists and 2 Brazilian historians to think collectively with scholars from the United States about questions of the definition of slavery. The videotape is online, accessible through the website of the program in race, law, and history. Building on that visit, the law school will host 1 and perhaps 2 Brazilian jurists working on these issues in the fall term of 2014. 4, one mechanism for sharing findings is the great institution of the op-ed. We actually have with us today a journalist from France's daily newspaper Le Monde, who arranged in the midst of the French parliamentary debates for an op-ed to appear that could draw the link between historical and contemporary slavery, helping to overcome the impression that adding the term slavery to a modern criminal code would be simply rhetorical. Finally, with these institutional initiatives come student initiatives. One of our law students will travel to France this summer to study the implementation of the changes in the French criminal code. Past semester, a Brazilian law student was here. She now keeps us posted on developments in Brazil. And undergraduate courses offered through the program in international and comparative studies will open out onto linkages between historical slavery, contemporary slavery, and the field of human rights. So our great hope is that if we keep talking and listening, and sharing ideas and examples and model statutes and legal guidelines and practical experiences, we can gradually help to expand the understanding of phenomena that represent one of the most egregious forms of inequality in today's world: the exercise over persons of the kinds of powers that once attached to a right of ownership, but that now hide within societies in which the ownership of persons has long been repudiated. Within the large field of human rights, I think this is one of the points at which scholarly inquiry can be particularly important. For this is a form of exploitation that constitutes an internationally recognized assault on human dignity, but whose suppression requires an exceptional combination of historical thought and legal and political action. Thank you. Yeah.
Just wanted to say, if you have questions, to use the microphone. This is being filmed, and so they won't be able to hear you without a microphone. If I can call them.
I'm happy to take questions, observations, other contributions to the litany of things that are being done at Michigan that are relevant to this, or challenges. Someone who wants to say, it is just rhetorical overreach. David Cohen, yes. And Pat Lord will bring you a microphone. Yeah.
That was just brilliant and beautifully constructed. An amazing argument. And I just see a shadow. If one compares it to the genocide conventions, that there is an international, is that us feeding back?
I don't know, but I'll stand in the corner.
Okay.
Yeah.
That there is a similar international convention on genocide. Yet there's also arguments that some genocides are unique and cannot be compared to others. Just as the argument was made a decade or so ago in the reparations discussions around the Atlantic, that nothing can be compared to the experience of the enslavement of people of African descent. And I wonder how that argument flows around the discussion of contemporary enslavement.
Thank you, David. That question I think is quite important. What do people envision is at stake in expanding the application of a term that seemed for a time as though it was actually confined to a specific experience. Philippe Bernard, who's here from Le Monde, I think would agree that in France, this argument had some traction. There were certainly some people who felt, particularly after the French Parliament had declared the transatlantic trade in African captives to be a crime against humanity, there was some, as a historical matter, there was some worry about using the large word slavery to apply to contemporary circumstances. I think some version of that has influenced some political figures. What was interesting in France this summer was to watch how quickly, though, opinion shifted. It seemed as though that was the kind of argument that would be raised in a face-to-face debate between two people. No, you can't use that word because you're diminishing the uniqueness of a previous experience. But once the question came fully out on the table and the attorneys who represented, particularly these young women who'd been held in these conditions, brought the narratives forward, I think that argument dissipated as people realized that over and over again, when prosecutors had tried to prosecute, the cases had fallen by the wayside. People had been acquitted, the charges were dropped. There was clearly a problem with the criminal code. And so by building in slavery and involuntary servitude and forced labor, they put all three in, I think actually they may be leaving a little room for maneuver for prosecutors and judges if in a given instance they don't want to invoke the full parallel with slavery, then they can move to involuntary servitude or even forced labor. I think that's, as a matter of judicial reasoning and political argument, there is tension there, but I think the change has been taking place relatively quickly. I had an interesting experience talking to the former president of the European Court of Human Rights, Judge Da Costa, and he was speaking about the case of Henriette Akofa, which the court had ruled to be involuntary servitude in 2005, the European court. When they condemned France, they said they'd not protected her against involuntary servitude. 5 years later, when the president of the court was speaking to me about the case, he kept referring to it as slavery. And I said, excuse me, but I had written a whole article on why they should have called it slavery, but instead they called it servitude, and now he was calling it slavery. And so I said, but didn't you make a distinction in the decision? And he said, oh, well, that was in 2005, you know. And I think what he meant was, in 2005, it still seemed a little novel to a group of distinguished European jurists to call conditions on the 10th floor of an apartment building in Paris slavery. But over time, the term simply came into currency. It didn't seem to diminish people's awareness of what had happened in the 18th and 19th centuries. So I don't mean to give a long-winded answer, but I think it's dialogic. And as far as the activists are concerned, if you can get the same conviction by calling it involuntary servitude and actually repress the activity, then the word is not the crucial thing. But if you're prohibited from using any of those terms for rhetorical reasons, then you get this situation where cases are dropped. I don't mean to give long-winded answers. It plays out quite differently in Brazil, where they've long used the term labor analogous to slavery, and that sort of creates an arm's length, analogous to, but the analogy is made in order to assimilate it to, and in order to say it's therefore prohibited. Yeah. Other questions? Bruce Mannheim, yes.
Yeah, Rebecca, this was absolutely liberating as a talk.
Well, thank you.
Partly for me personally, because I've been involved in conversations with people in Peru, actually mostly Michigan PhDs.
Yeah.
Your
the list.
About whether we should begin to rethink the system of agrarian estates in South America.
And compelled labor.
As slavery. And the major argument is people are being sold with the estates. Estates were until the 1960s, when in Peru they were abolished. They weren't abolished everywhere by then. Estates are being sold as estates of X number of families. People were branded to show their connection to the estate. It doesn't look like slavery in our sense, because individuals are not being alienated from the context of production and sold separately, but in all other respects, it looks and smells and
Like some kind of serfdom.
consequences
Yeah.
socially
Yeah.
of slavery. And so maybe I can turn this into a question: Are we beginning to think about this the right way as far as you're concerned? And might this be something we can pull back to and return to history in its disciplinary sense, and perhaps rethink the American past of the Americas
In that context.
racism.
Thank you for that question. And here the question having to do with the rooting of people on the land such that rights over them are transferred along with the transfer of land. Well, I've been very struck in talking to inspectors and prosecutors in Brazil. I think they are the logical bridge in many ways for Peruvian activists and attorneys and inspectors, and they've been meeting together and exchanging ideas. I think the reason they're perhaps the best bridge is because they deal so extensively with agrarian conditions in Brazil. So it's quite different from the one-by-one enslavement of individuals held isolated within Europe. This is large numbers of people, and you know the forms of recruitment. I mean, they're generally recruited many days' drive away from the place where they'll be taken to work in Brazil. They're not told the name of the plantation on which they'll be working, and particularly their wife is not told. In other words, the people who stay behind are not given any contact information. Then they're piled into the back of a truck. They're driven into the interior, often given a bottle of sugarcane rum or worse, or drugs. And they arrive having signed on to do a per hectare kind of labor, and they discover that what they thought they could do in a day, they can't possibly do in an Amazon rainforest in a day, and they're told, yes, and you must buy your chainsaw first, right? So you begin your work with the debit for your travel, for your food, for your lodging, and for the chainsaw. So you have a kind of debt labor established. Now, because the Brazilians use the term labor analogous to slavery, they are actually able to do quite a lot of prosecuting and inspecting in those kinds of circumstances. So my hunch is that it will be less the definitional work than it will be practical consultation among people who do inspections and prosecutions to figure out what kinds of elements should be built into the crime, if a crime is going to be defined in the criminal code, if a code is going to be revised, and what kinds of mechanisms do they have for locating the evidence of those elements of the crime. Defining the elements of the crime turns out to be extremely important if it's going to go through the criminal courts. Defining as a crime to begin with, and then defining the elements. And I think this is the alarmingly smart move of the landowners, which is to now try to just tinker with the elements of the crime. One of the things that's interesting in Brazil is that they've developed a technique, which is they have mobile teams, and they come together from all over the country to do inspections in complete secret. They do not divulge where they're going to go until the driver and the person in charge of the inspection goes, and they barrel into the countryside having had denunciations of conditions and try to get there before the evidence can be destroyed. Because if anyone knows they're coming, they prepare for the inspection.
That's incredibly helpful.
Yeah. Okay, now I see lots of hands. Okay, let's see, Michelle Moreno, and then you. Yeah. Okay, Michelle.
Hi, Professor Scott.
Hello.
You mentioned several times that the exact definition in Brazil, the legal code, is labor analogous to slavery.
Yeah.
You also mentioned that landowners are trying to tweak it.
Yeah.
That there's a lot of importance on the actual definition.
Yeah.
Do you have any specifics on exactly how they're trying to change it so prosecuting slavery would be extremely difficult?
Okay, I think there are two things. One is, right now, the law that criminalizes enslavement in Brazil has the feature that the penalty is sufficiently low that if the case takes a long time to work its way through the courts, the enormously overburdened Brazilian courts, a statute of limitations kicks in, even after the prosecution's begun. It's a different system, and the case will be dropped. In other words, if the maximum penalty is only 2 years, and if the case has already been working its way through the courts for 3 years, I'm using imaginary terms, then it can be dropped. So this means that the strategy for defendants who've been accused of enslaving is obvious, right? Get lawyers who will make it take forever. So there's been interesting new work done by a judge, Carlos Haddad, who worked in in Pará, in Brazil, and he decided to openly put a priority on on these cases. He would hear them first so that they couldn't fall into this category. So I think there's interesting work to be. This is like activist judge in the literal sense, the self-proclaimed activist judge who says, this is a priority for the communities in which we work. The whole community is injured if these practices are not stopped. And so these cases, I want them on my docket. I want to hear them now. In terms of changing the elements of the crime, the key move that looks like it may be happening, we're getting sort of news about this every week because the discussions are happening in a committee in Brasilia right now it's a complicated story, but a committee of the Senate. What they will do will be to try to make physical constraint over the physical mobility of the person required for the definition of the crime. That way, if there have been some armed guards around and people believe that there might be armed guards again, and people don't have ID and don't have any way to get out, but don't leave, then the claim could be made the person was not physically restrained. Now, the irony here is maybe there's some work for historians to do, because of course much of the time persons held in slavery in the United States were not at every moment, chained to the wall. What owners wanted was the human capacity of those persons. They therefore gave those persons a certain amount of physical mobility in order to do the things that were needed to be done. So it's a very artificial limitation. It tries to turn slavery into something, it's not quite kidnapping, but it tries to look for the elements of unlawful imprisonment and narrow it down so that you drop away everything to do with labor conditions, everything to do with affronts to human dignity, everything to do with sanitation, hygiene, payment levels, improper labor practices. You drop all of that out and just leave that one little nucleus. So that'll be a real problem if they succeed in making that change. I'm optimistic that they won't, but it's it's going to be part of this strategy. Yeah.
Yes. I don't know if I need. I'll speak loudly.
Yeah.
I was wondering if you
actually she will bring you a microphone because of the taping. They need the microphone in order to have the record. Yeah. Yeah.
Thank you for your talk and for sharing your documents.
Yeah, they're kind of
to see them on the big screen.
Kind of neat documents,
yes. Yeah. My question is if you think the increasing willingness or possibility of understanding these human relationships as slavery is connected at all to increasing awareness and international law around child trafficking and the rights of the child, and how you see those unfolding in connection or on parallel tracks. And so I'd just like to hear a little bit about, especially over the past 10 or 15 years, where I think that momentum could be kind of cross-fertilizing.
Thank you. Great question from Alexander Stern. I'll identify people for the purposes of the recording. So the question, how is this connected more broadly to questions of human trafficking and child trafficking in particular? I think the child trafficking element is actually quite important because it makes it clearer how, I think intuitively to observers, it's clearer how one can impose isolation and psychological coercion on a person who's young and often either a refugee or someone who's entered a country and their papers have either expired or been confiscated. So I actually think, again, in the French case that Philippe Bernal knows quite well, I think in that case the youth of the victims was quite important. Henriette Akofa, when she was brought to France, was only 15. So I think there, the sense of, gee, why didn't she run away, which is usually the first kind of disqualifying reflex, people don't as quickly assume that, because they do assume that a 15-year-old who's told by the adults in a household, you realize that if you ever talk to the police, they're going to put you in prison, right? It's a plausible claim. There's actually a poignant moment in Henriette Akofa's autobiography, and she was caring for children. One of the reasons she never ran is because she was responsible for the children in the household. The only time she was allowed outdoors was when she was caring for the children, and she never wanted to abandon the children. But there was one day when she was in a park, and there was a policeman, and she'd heard all this talk about papier, tu n'as pas de papier, you don't have papers, you don't have papers. And she just walked up to the policeman and said, what are papers? Why is it such a bad thing not to have papers? And that was a moment when, if there had been training sessions for members of the police force, they might have looked at the situation and thought something is amiss that this child is asking me this question. She was only 15 or 16. So I think the element of youth in some of the victims, particularly these domestic servitude cases, is quite important. The larger question of trafficking and slavery, I had one very interesting conversation with Bridget Carr the other day, in which she and I sat down with pencil and paper and tried to figure out, what would be the Venn diagram as between trafficking and slavery. And she was sort of saying, is it like that? Like there are a small number of things that are the same, or are they mostly the same and a few things that fall outside? This is why it's really interesting to do seminars on subjects like this, because I think we really need to think it through. She uses the laws as currently written in the United States that define trafficking. Those laws are quite well drafted. They enable quite a number of circumstances to be encompassed. It doesn't have to involve crossing an international boundary. She can actually encompass within those laws many of the things that one would wish to be able to prosecute. So I think there's a fairly productive dialogue between folks working on child trafficking and human trafficking and people thinking about slavery. But we're still in a little bit of a gray zone, because a lot of the imagery around trafficking is kind of movies and things sort of give this grab and transport image. Whereas of course, many persons who end up in circumstances analogous to slavery are not aware in the first instance that they are being trafficked. They may believe themselves to be signing a valid contract for valid labor in the Amazon. And one of the interesting things about the Brazilian case is that there's plenty of work in the Amazon. You could be a perfectly honest, well-informed person and believe yourself to be signing a labor contract. And in some cases you would be. And you would go off there and you'd work hard for low pay, but you'd be a worker, right? In a small percentage of cases, it's going to be a fraudulent trap into slavery. And so this is one reason why labor inspectors are particularly useful in this struggle, because they can try and pull apart some of the things that cause the person to be in that situation in the first instance. Yeah. We probably have time. Sue Ann Caulfield, yeah. And I think there's a microphone. Pat, can you? Sue Ann is right here, yeah. Great to give a talk where you know so many of your questioners.
So I was wondering about other kinds of languages against slavery specifically, and whether there are any parallels. So, for example, the religious church. So the church was the one, that's where the whole justification for Western slavery originated, as you pointed out. And yet in the 19th century, people were ignoring those justifications. But does the church ever get involved? And how, because in earlier centuries, the church is thinking about this and defining when it's legal and when it's not legal, when it's moral, when it's sinful and not all the time. And so I wonder if that ever happens. And then I was thinking, well, and then there's the parallel to the present as well, because the church is so involved in something, especially in Brazil, in the movements against slavery and trafficking and for rural rights in general. And so I'm wondering, how is the church involved also in activism around this legal debate? And are there religious, so are religious people thinking philosophically about defining?
Thank you for that question about the role of the church in really historically, both in justifying and then some branches of the church challenging slavery, and then in the contemporary period. Well, as you know, because you're a specialist on Brazil is exactly the place to look at this. And I think there's a 2 or 3 part involvement. One is simply as a practical matter, it was the Pastoral Commission on Land that first, that is to say the Catholic Church's own Pastoral Commission in Brazil, that first really tried to bring these issues of agricultural enslaved labor in the Amazon onto the national agenda. So the first part of the answer would be in Brazil, clearly in terms of activism, very important. Second element would be the very most thoughtful book that we have on this is the one by Ricardo Rezende Figueira, who began as a priest a Catholic priest in the Amazon, and after 10 years of ministering to people in these areas where these practices were so widespread, he moved to Rio de Janeiro and did a PhD in sociology and wrote as his doctoral dissertation a study of that phenomenon in that region. And it's much the closest ethnographic work. There'd be a big translation task for Latin American and Caribbean Studies at Michigan to take on. It's a really terrific book. So figures like Ricardo Rezende, who've been able to bridge between moral witness, the conviction of a wrong that came from actually ministering to people, and then shifting into an analytic mode. He runs one of the working groups on contemporary slavery in Rio de Janeiro. The third point is one that goes beyond the specifics of any given country. And my colleague Joe Vining knows quite well about this. The concept that often exists kind of counterpoised with the concept of the exercise of the powers attaching to a right of ownership. If the 1926 international law language is framed in terms of the powers that would accrue to a property right, the other mode of interpretation of slavery, contemporary slavery, is to anchor it in the idea of violations of human dignity. So in that sense, it circles back to 19th century abolitionism, which itself has a strong religious component and which itself deals with and addressed the question of human beings treated in ways that no human beings should be treated. And so there's actually a kind of philosophical crossing that's happening as the concept of violations of human dignity comes to be seen, particularly in Brazil, as one of the components that signals when a labor practice has passed below a threshold such that it is simply morally unacceptable and should be viewed not as just a violation for which you're fined, but as something akin to slavery. So examples of that at a practical level, the inspectors tell me it often has to do with the conditions of living and when human beings are made to share conditions appropriate to farm animals, when people have no source of water other than the same trough that the cattle drink out of, when people have as their only place to sleep a piece of plastic that's in the middle of the field with just nothing more than a straw roof over it. That those, from the point of view of inspectors, constitute in and of themselves violations of human dignity, and therefore they trigger that element of the sort of scale of labor violations, at which point they start to speak of conditions analogous to slavery. Now, the concept of human dignity philosophically is very complex. It's very closely related to church thinking. It's not an easy one to work with. And in the case, this is a parenthesis, but in the case of French law, it actually has not been helpful because there was an element of the criminal code that criminalized violations of human dignity. But then each judge would try to imagine in his or her own head what would constitute a violation of human dignity. And in the case of young women held in involuntary servitude, cooking and cleaning, the judges would say things like, well, and they say this in the Henriette Akofa case, well, they didn't beat her and she wasn't raped. And so they're envisioning that it would require a different kind of violation to trigger the dignity concern. They're failing to see that that the constraint is itself, that the broader violations are themselves the violation of dignity. They're looking for something that evokes some sort of torture or something like that. So the criminal code element that could have been used based on human dignity has never worked. I don't think anybody's ever found a conviction in those circumstances using the dignity provisions. But they're there, they signal something about what ought to be captured in the criminal law, but by themselves they don't work very well. So I think the Brazilian law is particularly interesting because the inspectors have kind of set up a dialogue between dignitary concerns, labor violations, a category of labor violations which then become analogous to slavery. So one more question. Virginia Stein, and Pat Lord will bring you a microphone.
Rebecca, thank you for a very enlightening speech.
Thank you.
Brilliant.
Thank you.
I am wondering how the cases in France surfaced. They were undercover, obviously. amnesty
Mm-hmm.
and were brought before the Luxembourg Court, the European Court of Justice.
A great question. Do you want to say another word, or do you want? That's it. Okay. So the question: how do they come to view in the French courts of first instance, and then who appeals them to Strasbourg? Who takes them to the European Court of Human Rights?
Brought the cases
To European Court. Okay. The pivot to the answer in both cases is the Committee Against Modern Slavery, which is a non-governmental organization of activists in Paris. But the way the pivot works is very interesting. Henriette Akofa, the young woman who was held in that apartment, didn't dare talk to anyone. The people who held her had told her never to speak to anyone outside the family. When going down, I think it was in the elevator of the building or to take the trash out or something, she crossed paths with one of the neighbors, and she just suddenly blurted out her story. The neighbor was a woman from Sweden, and she had no idea what to do. It was, however, 1998. It was the 150th anniversary of France's 1848 second abolition of slavery. So there were big articles in the press, including Le Monde, about the abolition 150 years ago. And in one of those articles, there was a paragraph that said, and there's an organization today in France called the Committee Against Modern Slavery. So the neighbor looked it up in the phone book, called the Committee Against Modern Slavery, and reported what was happening. And the police came to the front door, and the presumptive evidence was sort of right before their eyes. So the Committee Against Modern Slavery is often the one that takes on legal representation already in the courts of first instance. The state prosecutor, of course, brings the criminal charges. The Committee Against Modern Slavery often accompanies the victim and provides shelter to the victim. So they really are both a legal and an outreach organization. Then they followed the case, they worked on the case all the way through until the final appeals tribunal in France said that nothing was owed to the young woman except back pay and no penalty to the enslavers. So at that point, the Committee on Modern Slavery brought the case to the European Court of Human Rights. And so that's what brought it into view. And that committee has been extremely important in these cases. So it's actually it's a very interesting example of the way in which people, I've been to their office, it's just a couple of rooms in a little house somewhere. You know, it's not a big organization. They do not have large foundation support of the kind that we might expect in an NGO. But they know the law, and they follow these cases, and they follow up, and they provide protection. So thank you. It's a good question with which to end. Thank you. Thank you, Ken.
With that, we'll thank Rebecca Scott once again.
Thank you.
For an excellent presentation.
Thank you. It's been fun.
Wonderful.
Thank you.